Obligations and contracts. Nature of obligation. Obligation defined. An obligation is a juridical necessity to give, to do, or not to do. In Makati Stock Exchange versus Miguel Campos et al., the Supreme Court cited Justice J.B.L. Reyes, who offered the definition given by Arias Ramos as a more complete definition. An obligation is a juridical relation whereby a person, called the creditor, may demand from another, called the debtor, the observance of a determinative conduct, the giving, doing, or not doing, and in case of breach, may demand satisfaction from the assets of the latter. Distinguished from right, the High Court likewise ruled in Makati Stock Exchange versus Campos et al. That right and obligation are legal terms with specific legal meaning. A right is a claim or title to an interest in anything whatsoever that is enforceable by law. An obligation is defined in the Civil Code as a juridical necessity to give, to do, or not to do. For every right enjoyed by any person, there is corresponding obligation on the part of another person to respect such right. Basic concepts involved in obligations. The definition under the new Civil Code involves civil obligation, which is said to import three concepts. A. Credit. Option of a person to demand a patrimonial prestation and which the law will enforce. Death. Coercible duty of another to render a prestation or observe a particular conduct. C. Responsibility. Responsibility of the debtor to satisfy the claim of the creditor from the debtor's patrimony in case of breach. This is not equivalent to a legal duty or obligations in general. Civil obligation distinguished from natural obligations. Civil obligation, perfect obligation, which involves the concept of death. Credit and responsibility should be distinguished from natural obligations. Imperfect obligation. Civil obligation can be enforced in court, while natural obligation cannot be enforced in court. Natural obligations' force and compliance is only directed against a person's conscience. Natural obligation is said to be based on equity and natural law. Requisites of obligations. A. The vinculum juris or juridical tie, which is the efficient cause established by the various sources of obligations. The object, which is the prestation or conduct required to be observed, to give, to do, or not to do. And C. The subject persons, who, viewed from the demandability of the obligation, are the active obligee and passive obligor subjects. 2012 bar. 1. Prestation. The conduct required to be observed, which includes to give, to do, or not to do. 2012 bar. Number 2. Passive subject. He is the obligor or debtor, the person who is supposed to perform the prestation. He is the one who will give, who will do, or who will not do. Number 3. Active subject. He is the obligee or creditor. The obligation of the obligor is owed to him. He is the one who can demand the performance of the prestation. He will be the one to whom the thing involved will be given, or the one for whom something will be done, or will not be done. Sources of obligations. The different sources of obligations enumerated in Article 1157 of the new Civil Code are as follows. 1. Law. Number 2. Contracts. 3. Quasi-contracts. 4. Delicts. And 5. Quasi-delicts. Except for contracts, the other sources of obligations are obligations without an agreement. 2007. A. Exclusivity. The juridical necessity is created by any of the sources of obligation identified in Article 1157. There is no other source of obligation other than those mentioned in Article 1157. As the Supreme Court ruled in one case, an obligation imposed on a person and the corresponding right granted to another must be rooted in at least one of these 5 sources. Law. Obligations arising from law are not presumed. Only those provided for by law are demandable. Classifications of obligation. Primary classifications. Pure obligations or conditional obligations. We can find it on Article 1179 from 1192. Obligations with a period from Articles 1193 to 1198. Facultative obligations or alternative obligations from Article 1199 to 1206. Joint obligations or solidary obligations, Article 1207, 1222. Divisible obligations and indivisible obligations, Article 1223, 1225. Obligations with a penal clause, Articles 1226 to 1230. Secondary classifications, unilateral obligations or bilateral obligations, principal obligations or primary obligations, real obligations or personal obligations, positive obligations or negative obligations, legal, conventional, and penal obligations, individual or collective obligations, obligations to do, obligations not to do, and obligations to give. Number 8, specific or generic obligations. Effects of obligations. Obligations to give. Purpose of obligation to give. To transfer ownership. Example, delivery to the buyer of the thing sold. Or 2, to transfer of mere possession or right. Example, delivery to the tenant of the house sought to be leased. Things to be delivered in an obligation to give. The thing may be real or personal property, consumable or non-consumable, fungible or non-fungible. See Part 2. It may also be generic or determinative things. A. Generic things. The things or property involved is referred to only by its class or genus. Examples: to give a sack of rice, to give 5 mangoes, or to deliver a kilo of corn. Determinative or specific things. The thing or property involved is particularly designated or physically segregated from the members of its class. Examples: to give the watch that is now in the wrist of Mr. A, to give the only dog of Mr. B, to deliver all the rice in the warehouse of Pedro in 123 Rizal Avenue, Manila, or to deliver the car with plate number 123 XYZ. Obligations that are included in obligation to give a determinate thing. From Article 1163. Principal obligation involved. Obligation to give a determinate or specific thing. Number 2. Accessory obligations. Obligations that are deemed included in the obligation to give a determinate thing. These include the following. 1. The obligation to take care of the thing to be delivered with the diligence of a good father of a family. Number 2. The obligation to deliver the accessions and accessories. And number 3. The obligation to deliver the fruits from the moment the obligation to deliver arises. Duty to exercise due diligence. The obligor must take care of the thing to be delivered with the diligence of a good father of a family. The duty to exercise due diligence is imposed because if the same is not present, the obligation may be rendered illusory. If the thing will not be preserved, then it would be unfair to the obligee or creditor who may be receiving a property that is already damaged, or he may not receive the property altogether because it may have been destroyed in the meantime. Standard. The standard being used is the diligence of a good father of a family. Sometimes the good father of a family is called a reasonable man, or a man of ordinary diligence or prudence. In Francisco versus Chemical Bulk Carriers Incorporated, the Supreme Court restated the rule that generally, to determine the diligence which must be required of all persons, we use as basis the abstract average standard corresponding to a normal orderly person. Exception: when the standard is not diligence of good father. When the law requires a different degree of diligence. Example, Articles 1733 and 1755 of the New Civil Code requires common carriers to exercise extraordinary or utmost diligence in the vigilance over goods and passengers that they contracted to carry. Members of the Monetary Board, officials, examiners, and employees of the Bangko Sentral ng Pilipinas are required to exercise extraordinary diligence in the performance of their duties. When the parties agree on or stipulate a different standard of care, disabled person, with respect to disabled persons, the Supreme Court adopted the rule stated in this order's work on torts and damages, stating that however one who is physically disabled is required to use the same degree of care that a reasonable care for person who has the same physical disability would use. Physical handicaps and infirmities, such as blindness or deafness, are treated as part of the circumstances under which a reasonable person must act. Thus, the standard of conduct for a blind person becomes that of a reasonable person who is blind. The circumstances that specifically pertains to the blind person are considered. Effects of failure to exercise due diligence. The obligor or debtor may be liable for damages. Number 2. The obligor or debtor is liable even if there was fortuitous event. The right to the fruits. Article 1164 provides that the creditor has the right to the fruits of the thing from the time the obligation to deliver arises. This applies only to an obligation to give a determinate or specific thing. Illustration. The moment the contract of sale of a specified cow is perfected, all the fruits of that cow should be delivered. For example, Mr. X sold a specific cow to Mr. Y. Mr. Y paid the price and agreed with Mr. X that Mr. X will deliver it 3 days thereafter. All the fruits of the cow, like its young or calf, from the time they entered into the contract of sale up to the time of actual delivery, should be delivered to the buyer, Mr. X. If the obligation is to deliver any cow, generic, there is no need to deliver the calf of the cow of the seller because any other cow can be delivered. Real rights and personal right. Real right over the thing to be given is acquired by the obligee or creditor only upon delivery. What is being referred to is the real right of ownership. However, the moment the parties entered into a contract, the creditor has the personal right to compel the debtor to deliver the thing. Example, if Mr. X agreed to sell his horse to Mr. Y for a specified price, Mr. Y has the personal right to compel the delivery of the horse. Mr. X also has a personal right to compel Mr. Y to pay the price. The moment the horse is delivered by Mr. X to Mr. Y will acquire real right over the horse. In other words, he will become the owner. Obligation to deliver accessions and accessories. The obligation to deliver or give a determinate thing carries with it the accessory obligation to deliver the accessions and accessories. Remedies. Remedies of the obligee, creditor, in obligation to give a determinate thing. Specific performance. In case the debtor or obligor failed to give or deliver what he is supposed to give or deliver, the obligee or creditor may file an action to compel the debtor to give or to make delivery. This is called specific performance. For example, if the obligation is to deliver a specified chair, the creditor may file a case in court to compel the debtor to deliver the chair if the debtor failed or refused to deliver. Action to preserve. Since the obligor must take care of the thing before delivery, the creditor may also file an action for the preservation of the thing. Action for damages. Those who, in the performance of an obligation, are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages. This is also included in what is referred to as equivalent performance. Remedies in an obligation to deliver a generic thing. In an obligation to deliver a generic thing, The creditor may either ask for A. Specific performance or B. Substitute performance. Specific performance, although Article 1165 mentions only a determinate thing, specific performance is also applicable to obligations to deliver generic things. In the case of generic things, where the quality and circumstances are not stipulated, the creditor cannot demand a thing of superior quality, and the debtor cannot deliver a thing of inferior quality. Substitute performance. If the thing is generic or not determinate, the second paragraph states that the obligee or creditor may ask that the obligation be complied with at the expense of the debtor or obligor. For example, if the obligation is to deliver a sack of rice, another person may deliver the rice if the obligor failed or refused to deliver at the expense of the said obligor. This is known as substitute performance, because instead of the debtor, it is another person who will substitute him in the performance of an obligation. Action for damages under Article 1170 is also available in case of breach of the obligation to deliver a generic thing. Remedies of the obligee creditor in case of failure of obligations to do. Article 1167. In an obligation to do, the prestation consists of performing a certain activity, physical or intellectual, distinct from that of the delivery of a thing. Total failure to do. If the debtor or obligor fails to do what he is required or obliged to do, the activity shall be performed at his debtor cost. Example, if Mr. X is obligated to paint the fence of Mr. Y, and Mr. X failed to do so, Mr. Y can have somebody else paint the fence at the expense of Mr. X. 1. The debtor cannot be physically forced to perform the obligation because that would be contrary to his liberty. Example, the debtor cannot be forced to perform his obligation to repair a piano. B. If only the debtor can perform the obligation, like in case the obligation is personal to the debtor because he was chosen by the creditor because of his qualification or character, the act cannot be done by somebody else. Hence, the remedy is to recover damages. Failure to do in accordance with the tenor of the obligation. If the obligor did what he was supposed to do but in an erroneous manner, the obligee or creditor can also have it done by somebody else at the debtor's expense. Example, Mr. X is supposed to erect a stone fence which should be 5 feet. If Mr. X constructed a 2-foot fence, the creditor or obligee can have the fence completed at the expense of the debtor. Failure to do correctly or performing the obligation poorly. The obligee can have what was poorly done be undone. And 2, he can have the obligation done by somebody else at the expense of the debtor or obligor. Example, if the fence in the previous example was poorly done because it was uneven and very weak, the fence can be removed and another person can be made to construct the fence properly at the expense of the debtor or obligor, Mr. X. Remedies of the obligee creditor in an obligation not to do. If the debtor did what he was obliged to do, it can be undone at his expense. Example, if the debtor or obligor is obliged not to construct a wall which is more than 2 meters high, and he constructed a 3-meter high wall, then the height of the wall may be decreased by 1 meter at his expense. Exceptions. What the debtor did not cannot be undone if it is 1. An accomplished fact or fait accompli, or 2. It is impossible to undo. If the debtor did what he was obliged not to do, but is impossible to undo, the debtor is liable for damages. Example, Mr. A was obliged not to be involved in activity that emits noise beyond a certain decibel, but he did it just the same for 1 day. The act of Mr. A of creating noise cannot be undone. Hence, the remedy that is available is for damages. Performance of the obligation. Compliance of the debtor or obligor requires the following. identity of obligation, and B, integrity of obligations. Identity of obligations. This means that obligations must be complied with precisely. That is, what was obliged to be done or given is exactly what should be done or must be given. What is obliged and what is performed must be identical. If the obligation is to give a horse must be given rather than a carabao. Integrity of obligations. This means that compliance of an obligation must be complete. Breach of obligations, non-compliance, or non-fulfillment. There is breach of obligation if there was non-compliance altogether, or if the compliance is without identity or integrity. Classification of breach. Breach may be classified as total breach or partial breach. It may also be total non-compliance or defective compliance with the obligation, total breach. Breach or non-fulfillment by not doing anything at all or doing all the things that is not supposed to be done. Example, the obligation imposed by law is to construct a firewall in his building, but the owner did not construct a firewall. Defective performance. 1. Breach by doing something that was not agreed upon. Example, the obligation is to deliver a motorcycle, but what was delivered was a horse. Breach. 2. Breach by partial performance. Example, the agreement is to deliver 5 sacks of rice, but the obligor delivered only 2 sacks of rice. Number 3. Breach by poorly or badly performing the obligation. Example, the obligation is to construct a chair and the chair was made, but his feet were uneven. Number 4. Breach by delay in the performance, that is, the defect relates to the time of performance. Number 5. Breach by performing the obligation but not in accordance with the specifications, terms, and conditions. Modes of breaching the obligation. An obligation may be breached through fraud. 2. Negligence. 3. Delay. 4. Any manner that contravenes the tenor thereof. Causes of non-performance. Cause that can be attributable to the obligor or debtor. Fraud, malice, negligence. The obligor or debtor is responsible. 2. Cause that cannot be attributed to the obligor or debtor in whole or in part. Fortuitous event. The obligor or creditor is not responsible. Contravening the tenor of the obligation. The last mode of breaching the obligation is a catch-all mode that covers all other cases of total breach or performance of the obligation without integrity or identity. It may constitute breach through defective performance, as enumerated earlier. Effects of non-performance. Article 1170 provides that those who are guilty of breaching their obligations through any of the modes provided therein, fraud, negligence, delay, or any manner contravenes the tenor, are liable for damages. Extent of damages. Article 2201. The obligor who acted in good faith shall be liable for the damages that are the natural and probable consequences of the breach of the obligation and with which the parties have foreseen or could have reasonably foreseen at the time the obligation was constituted. In case of fraud, bad faith, malice, or wanton attitude, the obligor shall be responsible for all damages which may be reasonably attributed to the non-performance of the obligation. Essential requisites of action for damages under Article 1170. 1. The existence of a perfected contract. 2. The breach thereof by the obligor or debtor. And 3. The damages which the obligee or creditor sustained due to such breach. Other effects of breach. The obligor may be liable even if there was fortuitous event, or the creditor may be required to bear the loss. Number 2. There may be liability to pay interest. Breach through delay. Article 1169. Delay refers to non-fulfillment of the obligation within the time agreed upon or within the time contemplated by the nature of the obligation. There is non-fulfillment with respect to time. Delay is also called mora. By its nature, there is no delay in obligations not to do. Kinds of delay or mora. Mora solvendi. delay on the part of the obligor or debtor, 2012. Mora solvendi ex re, delay in obligations to give. Mora solvendi ex persona, delay in obligations to do. Mora accipiendi or creditoris, delay on the part of the creditor or obligee. Compensatio more, both parties are in delay. 2012. Requirements before debtor can be considered in delay. Before the debtor or obligor can be considered in delay, the following requirements must be present. The obligation is positive, to give or to do. The obligation is demandable and liquidated. Number 3. The obligor delays for reasons imputable to him. Number 4. There must be demand, whether judicial or extrajudicial, and the debtor failed to comply. 2012. Meaning of liquidated. A claim is liquidated when the amount and time of payment is fixed. If acknowledged by the debtor, although not in writing, the claim must be treated as liquidated. A demand is liquidated if the quantification is established with reasonable certainty. Examples: if the debtor is supposed to pay on January 2, 2025, there can be no delay before such date. The obligation is not yet demandable. If the amount of the obligation is still undetermined, as in the case where the amount of expenses incurred by the injured party, who is supposed to be paid by the obligor, is not yet established, then there can be no delay because the obligation is not yet liquidated. If the proximate and only cause of the delay is a fortuitous event, then there can be no delay for which the obligor is liable. The tenant is paying the monthly rentals for the property that he is leasing, but the landlord refused to accept. Demand. Demand is indispensable before the obligor can be considered to be in delay. Demand can be either judicial or extrajudicial. Thus, sending a letter demanding compliance with an obligation is sufficient. However, even if there was no such letter or prior verbal demand, it is sufficient that there be judicial demand. In other words, filing the case in court is sufficient. Exceptions. Demand by the creditor shall not be necessary in order that delay may exist in the following cases: when the obligation so declares, when the law expressly so declares. Time is of the essence, when from the nature of the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract. When demand would be useless, as when the obligor has rendered it beyond his power to perform, or in reciprocal obligations when one of the parties failed to comply. Demand in reciprocal obligations. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. Delay begins from the moment one of the parties fulfills his obligation. Hence, in a contract of sale of a lot, there is no delay if the seller has not yet complied with its obligation to deliver the lot, and the buyer has not yet paid the price. Delay on the part of the seller commences the moment the buyer has fully paid the price, and the seller has not yet delivered the lot, as agreed upon. Breach through fraud. Fraud is an intentional evasion of the faithful performance of the obligation. It is the deliberate intention to cause damage or prejudice, the voluntary execution of a wrongful act, or a willful omission, knowing and intending the effects which naturally and necessarily arise from such act or omission. The fraud referred to in Article 1170 of the Civil Code is the deliberate and intentional evasion of the normal fulfillment of the obligation. This also amounts to bad faith or malice. Applies to all obligations. Responsibility arising from fraud is demandable in all obligations. There can be fraud in the performance of any obligation arising from contract, and it may also be fraud that partakes the nature of delict. Fraud may also be the basis of an independent civil action under Article 33 of the new Civil Code. Examples of contractual fraud. 1. If the obligation of Mr. X is to deliver a diamond ring, he will be liable for fraud in the performance of the obligation if he delivers a ring representing to the creditor that it is a diamond ring, although he knew for a fact that the stone in the ring is just made of glass. Number 2. Parties in a contract cannot be allowed to engage in double-dealing schemes to dupe those who transact with them in good faith. 3. Selling a car, stipulating that the seller is not liable for hidden defects, where the seller knew that the car had a hidden crack in the engine. 2011. Bad faith or malice. The essence of bad faith consists in the deliberate commission of a wrong. It has often been equated with malicious or fraudulent motives. A finding of bad faith thus requires the concurrence of two necessary elements. 1. That the actor knew or should have known that a particular course of action is wrong or illegal. And number 2, that despite such actual or imputable knowledge, the actor voluntarily, consciously, and out of his own free will proceeds with such course of action. Future fraud. Any waiver of an action for future fraud is void. Consequently, the parties to a contract cannot stipulate in the contract that the parties will not be liable if they will commit fraud in the future. However, the prohibition relates to future fraud. Hence, if fraud was already committed by the debtor, the creditor may forgive him by disregarding such fraud. 1966. Breach through negligence. Breach or non-compliance with an obligation may also be done through negligence. Article 1173 provides that fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. 2014. Kinds of negligence. Negligence in the performance of an obligation can either be culpa aquiliana, culpa contractual, or criminal negligence. 1. Culpa aquiliana. This is quasi-delic, where the negligence itself is the independent source of obligation. Culpa contractual. This is negligence in the performance of contractual obligation. Culpa delicta. Criminal negligence. This is negligence that results in criminal liability. These include reckless imprudence or simple imprudence resulting in injuries, death, or damage to property.